Hello, my name is Jason Taylor, and I'm with the law offices of Jason E. Taylor. And I'm coming to you today with some critically important information. Right now in the North Carolina legislature is a bill, Senate Bill 477, entitled the Victims Fair Treatment Act. And it is critically important, and we're going to need your help. I'm going to ask you to contact your legislators. But first, what I want to do is talk to you about what the state of the law is now that's addressed in this bill. And then I want to tell you about what this bill will do and how it will change the law and how that will help you, your family, your friends, and everybody. And then I'm going to encourage you again to contact your legislatures. The Victims Fair Treatment Act, Senate Bill 477, addresses the issue of contributory negligence in North Carolina. We're one of 3 states left with this very draconian piece of law. What the contributory negligence says, right, is that if you run into me, this comes up in auto accidents, it comes up in medical malpractice, it comes up in nursing home, it comes up in just about any type of case where somebody's injured by the negligence of somebody else, right? So a rear-end impact case, I'm stopped at a stop sign and I get rear-ended. Now this is the most blatant kind of case. And I say, well, and I get hurt. The person who ran into me was negligent. They caused the harm, right? In most states, that's not a big deal. That's it. In North Carolina, as in a couple of other places, they say, well, we think you were 1% at fault. We think you contributed just a little bit to this. You put on your brakes too fast. You were sitting at the stop sign too long. The coast was clear. You should have gone forward. You hesitated. The ways this is brought up is innumerable. And in North Carolina, if you're 1%, if the jury thinks you're maybe 1% at fault in contributing to the event that caused the harm, even though the other person's 99% responsible, you get 0. It is an all or nothing game. Pretty much everywhere else, if you're 1% at fault, you get 99% of the value of your case. Well, here's what happens. So you've been harmed. You really didn't do anything wrong, but the other side's saying you did. You slow down too quickly. You hesitate. Anything they say, they say in some fashion, in some manner, you contributed. And they argue that all the way from the beginning. So you say, well, gosh, you caused all this harm to me. I have all these medical bills, all this lost time from work, all this pain, all this suffering. And they say, well, but we're not going to pay you for all of that because we think you're partly at fault. So they never offer to pay you for all the harm they caused. And they scare you, and rightly so, with that concern that ultimately at trial, even though if they can say at trial, they can tell the jury, hey, we think we made mistakes here. We think that we caused some harm, but the injured person did too. It's partly their fault. So make sure if you find us responsible, also check a box that says they're partly at fault. And then that's it. They don't even get to the numbers, right? It's 0. There is no number because you contributed. You can't be awarded anything. Right? So that's the current state of the law in North Carolina. What happens then? Well, people end up resolving their case for significantly less than it's worth because they're afraid of what might happen in the trial. So the insurance company is offering maybe 50% of the value or 20% of the value because they're saying, we think we got a good shot at getting contrib. And so people oftentimes out of that fear resolve for less. Also, those who don't resolve and they get zeroed out, well, maybe that person who was injured, who had to be helicoptered to the hospital and had months of care and they have $1 million in bills, they don't have the money to pay for that. Heck, they've lost their job. They've been out of work. They're permanently injured. The person who was 99% at fault, their insurance company isn't responsible because they got contrib. So that's the current state of the law, and it's horrible. It's old law. It's bad law, and it needs to go away. In Senate Bill 477, the Victims Fair Treatment Act intends to do that, and it proportions the fault. So you figure out how much the jury can decide how much that the victim is at fault. Were they 10% at fault? Well, then they should get 90% of the value of their case. It does what so many other states have already done, and that's determine, not make it an all or nothing game, but even the playing field. Make sure that the right things happen here. If you're 10% at fault, 15% at fault, then you ought to get that percentage of the value of the harms that you suffered minus what you're responsible for. But the all or nothing is not fair, and it hurts not only those individuals, it hurts the state. It keeps medical bills from being paid, keeps property damage from being repaired and paid. It causes no good. Now, the insurance companies have enjoyed that, but the citizens of North Carolina have suffered under it. And it is our great fortune that our legislators have figured that out, and they have gone to bat for the citizens of North Carolina with Senate Bill 477. So this needs to be acted on immediately. This is coming up by next week for our legislators to vote on. The sponsors, and they deserve a round of applause and money and a handshake and a thank you, is Senators Jim Perry, Danny Britt, Amy Gailey, and Vicky Sawyer. And to them I say, way to go, nice job. And to everybody who watches this video, please, this is one of those critical times for you and everyone you know to be protected where you deserve that protection. You have dealt with this antiquated, horrible law that has harmed so many, and here is the greatest opportunity in my legal career of almost 28 years, to fix this terrible thing. So contact your legislators immediately. Ask them to pass Senate Bill 477, the Victims Fair Treatment Act. Thank you so much.